Alright, hello everybody. Welcome back to the channel, the Butterfly Monkey channel. Hopefully you guys enjoyed the other video, the Newtons versus Evans, I believe it was, with the senator and the private trust and the public trustees that he had. Today will also be a trust case also. This one would be called Laverne Schulz and Barbara Schulz versus the Commissioner of the Internal Revenue. This court case deals with what they're calling a constitutional trust, where their income from sources outside the trust, they are not paying taxes for, or they're trying to get the trust to pay taxes for income that's being derived from sources outside of the trust. The court case that they reference heavily on is a case called Lucas versus Earl, and this is a 1930 case, which is another one, husband and wife. They had a trust, and where the husband was making independent income on his own and assigning it to the trust and then not paying taxes. In this court case, they flat out show or flat out tell you that it's the source of the income is where the instance of taxation occurs. The contract that you have afterwards on what to do with that income is irrelevant. In this court case, they held up that the trust was lawful, the contract and the agreement between blah, blah, blah. But nonetheless, it was a lawful thing to be able to do. To this case, it's a 1982 case. And it's similar, but it goes more in depth than the other one. But this will also show others who are thinking or doing the same with the income that they're making from their personal jobs or something like that, to assign it to the trust and then not want to pay taxes on it or think that they don't. So this starts, these appeals, which were consolidated by order of this court, are the tip of the iceberg, and they give an annotation here. Let's see what this says. As of late March of 1982, our docket had 7 similar cases set for appeal, but stayed pending decision in the instant cases. So Horvat versus Commissioner decided by unpublished order. Very denied, so the Supreme Court didn't want to hear it. Involved similar issues and has recently been published at the government's request. And then they give you the citation there, 671, Federal Reporter, 2nd edition, 990. Although Horvat is precedent for our decision in part, we have analyzed the issues afresh, since the parties could not, until very recently, cite or rely on that case. See Circuit Rule 35. The Commissioner's brief also lists 32 other cases, most decided by the tax court in the last 2 years, involving the same issues. So this right here is, they're telling you that this court case, they're going to break it down anew, like if it was anew before them, because there are so many similar court cases that are happening now in this time frame. The common issue is the appropriate treatment for tax purposes of so-called family or constitutional trust. The taxpayers contend that these are bona fide trusts taxable as such. They give you another annotation here. The taxpayers make a host of subsidiary arguments which are dealt with in 10 infra. So this is all down here. As Justice Holmes remarked in Earl, the validity of the contract is not questioned, and we assume it would be unquestionable under the law of the state of California in which the parties lived. Thus, here the taxpayers' arguments about freedom of contract and about the validity of their arrangements as a matter of Wisconsin law, which comprise large sections of consolidated briefs, are irrelevant. Let's see what 3 says. 3 gives us a tax case. 4 does too. We'll come back to those. I don't want to get distracted going back and forth. The commissioner argues that the tax court found that they are ineffective attempts to shift the incidence, the incidence of taxation by assignment of income under Lucas versus Earl. An invalid grantor trust under section 671 and 677 through 677 of the Internal Revenue Code. In the Schulz case, the taxpayers appealed deficiency findings, right? So they already got hit with this. So 5,000, 10,000, 4,000. The trust curiously appeals the decision that it is entitled to refunds. So about 750, 3,000 for this year. These are the years 72 and 73. In the White case, the deficiencies in the individual returns amount to about $300, $7,000, and $4,500 in those respective years. We affirm the tax court decisions in all 3 cases. Laverne Schulz, a Wisconsin dairy farmer and real estate broker, created his trust in 1972. Into it, and his wife, Barbara, conveyed all their real and personal property. So this is an estate that they're creating. Especially if all future income and so forth goes in it, that's an estate type trust. It's not a portion, right? It's everything. Including the farming and office equipment Mr. Schulz used to earn a living, and Mrs. Schultz's right to receive her salary as an employee in the county courthouse. So she's putting her income that she makes from the government, and he's putting well, it doesn't say yet, but so far he put the farming equipment that he used for his living, for his business, that he himself, his individual business. Everything from the dairy farm acreage to the real estate offices, filing cabinets to the family's television set and toaster became the trust res. So those that were listening last night, what did I say? You could put everything that you own into trust. In return, the Schultz received shares representing 100% of the beneficial interest in the trust, which they distributed to Barbara 50%, three children 15% each, and Laverne 5%. So the husband 5%, right? Everyone else got a higher. The initial trustees were Mr. and Mrs. Schulz and Ina Lungden, the wife of their bookkeeper. In 1976, one of the Schultz's daughters replaced Mrs. Lundgren. The terms of the trust called for it to last for 25 years, renewable for another 25-year term, with ultimate distribution to the beneficiaries or their heirs or legal representatives. Most actions could be taken by a majority of the trustees, but early termination required unanimous action. So these are all the powers that they're having. So here's the beneficial interest, right? These 3. And the initial trust, first there was 3 trustees, but then they got rid of the bookkeeper. And then one of the daughters replaced them. Under Internal Revenue Law, right? Like husband, wife, daughter, right? The husband is looked at as a senior role, priority role, or whatever term you want to use. And these are considered submissive persons, right? His wife and his daughter. That means that basically, if it could be found that damn near any action that they take together can be construed as if it's just him making the decision, because their decision don't matter if they are submissive to him. That is actually the word they use. But dependent, I guess, is probably another one too. Like brothers, sisters, and so forth like that can show independence away from the older brother type ideology or concept of authority, right? So if the younger brother, can take care of himself and doesn't need the older brother or things like that, and that can be shown, then it will be shown that he's not submissive to the older brother for trust purposes, at least. Most actions could be taken by majority trustees, right? But early termination required unanimous. Laverne Schulz drew a salary from the trust as its consultant in running the dairy farm and real estate business he had previously conducted, and reported the salary on his individual income tax return. So that's actually not a bad thing. No distributions were made to the beneficiaries. The trust paid tax on his net income. The accumulations to the trust minus the expenses of administration. In 72, it had income of $9,300 and expenses of just under $5,000. In 73, income was $25,000, expenses was 11.5, and in 74, trust return is missing from the record, so they don't even have this for court. Included in the expenses of administration were the items of as life insurance premiums on policies, insuring the Schulz, cost of maintaining and operating the family car, health care expenses for trustees, gifts and charitable contributions, license fees for a boat and a dog, educational expenses, and the cost of a home in Wisconsin, allegedly maintained for the convenience of Schultz's employer, the Schultz Family Trust, in those years, in 72 and 73. Russell White, so this is another case, right? Like I said, they're breaking down a couple of these cases. Russell White set up his family trust in the same manner and in the same year. The trust res consisted of the White's family house, stocks, life insurance policies, and assorted personal property. The trust's main asset was a contract entitling it to receive the income payable to Mr. White by his employer, Litho Productions. The beneficial interests in the trust were parceled out as follows: 20% to Mrs. White, 14% to each of White's 5 children, and 10% to Russell, to the Russell White Educational Fund, and nothing to Mr. White. Right, so his 10% went to a fund. Mr. White did, however, receive a manager's fee determined to be whatever amounts he needed to draw from the trust, which that automatically is an administrative power, which he's supposed to be a manager. So automatically he's already a trustee just because of that power right there. And he's going to get taxed as such. Initially, the trustees were Mr. and Mrs. White and Mrs. White's brother. The brother resigned immediately after the trust was formed and was never replaced. So now it's just both of them. The duration of the trust and the powers of the trustees were the same as in the Schultz family. In fact, that is not surprising since both trusts were drafted according to instructions contained in the pre-packaged kit. So this is for all you guys who like templates and so forth, and you want somebody's process, right? Because that's what that is right there. Someone's process. The tax returns of the White Family Trust show income $26.5 and administration fees of $25 of just over $21,000. Income $22,000 and expenses $16,000. These are for the years 73, 74, and the other one is not available. Among the administration expenses listed separately on the returns are health expenses of the trustees, household expenses, home and car insurance, and automobile lease, and trustees' lease for White's family car. Right? So these are comparable. These two paragraphs, they're comparing the two, and they're going to talk about both of them in this case, right? Breaking them both down. It takes no particular acumen in tax law to know that the Schulz and White family trust cannot be treated like ordinary trust. The only real question is which of several established doctrines the Internal Revenue Service should use to deny their existence as taxable entities. So here they're actually telling you like this. The only question is which one. They're saying that the Internal Revenue Service has several doctrines that will deny the existence of what this trust is. That's how messed up that they messed up in their trust. That they have multiple ways to penetrate it. And this is the judge stating just what he knows in terms of the tools that the service uses. Part A, attempted deduction of personal consumption expenses. It is fundamental to our income tax regime that personal consumption expenditures, food, clothing, travel, education, entertainment, do not generate income tax deduction unless they are somehow inextricably linked to the production of income. When taxpayers buy cars, travel, or take out life insurance policies, they make those expenditures out of after-tax dollars. The trust devices here are a transparent attempt to alter the state of affairs by turning all the family's activities into trust activities and all the family's expenses into expenses of trust administration. If this device worked, the Schultz and the Whites would, unlike the rest of us, make all their consumptive expenditures with pre-tax dollars. The Internal Revenue Service could disallow most of the administration expenses claimed by these family trust returns, but such an approach would be extremely inefficient. The service does not have the resources to audit every return, and the chance of avoiding an audit would only encourage this form of evasion. So he's calling it evasion, not avoidance. A broader-based attack on family trust of this type described here is possible, since the seminal case of Lucas versus Earl, it had been clear that income is taxed to the person who earns it, regardless of what arrangement he makes to divert the payment of it elsewhere. This is a rule of imputation that has nothing to do and does not affect the validity of the particular arrangement for purposes other than computing income taxes. In the absence of such imputation rule, taxpayers would be able to defeat the progressivity of the income tax rate structure by directing income to low bracket recipients. That result would obviously have occurred if Mr. Schultz or Mr. White or Mr. Schultz income had actually been distributed to their respective children and wives. But the potential deflation of the brackets exists even where, as here, there has been no distribution to the trust beneficiaries. So the key thing that I think to notice in here is that, say if I were to assign my income from some job that I'm making, right? No matter what, that tax, I have to pay that tax at that moment where it's happening. What I tell, human resources, HR, right, to send it here, right, to send it to this person. What do I mean by that? I'm sending it to my trust. That's to payee. That's who you're paying. I still got hit with the tax because I'm the one who did everything. I'm the one that incurred the tax. I'm just instructing it after the fact when the income becomes mine, right? When it becomes fully mine and the tax is gone. What do I want done with it? Okay, well, it's going to the trust. But nonetheless, the tax is at the source, at the instance that it was made. Where was I at? Right here? The impact on progressivity is only postponed owing to a special feature of trust taxation. Although the trust pays taxes on accumulated undistributed income as if it were an individual taxpayer, when accumulated income is finally distributed to the trust beneficiaries, at the latest when these trusts terminate, it is taxed to the beneficiary as if it had been distributed in the year it was accumulated, and the taxes previously collected from the trust are credited to the beneficiary's tax bills. The result is that only the beneficiary is taxed ultimately, and substantial tax deferral has been achieved. Thus, Earl's concern to prevent end runs around the progressive income tax rate structure is equally implicated in these family trusts, whether there are annual distributions or only a final termination of the trust. Under the rationale of Earl, it is a distinction without a difference that Russell White was a salaried employee and Laverne Schulz was self-employed before the creation of the trust. In either case, the income is spread so that no one is taxed at the higher marginal rates on the full amount. But Russell White's status as an employee at Litho Productions has encouraged him to make an argument that he is a leased employee, governed by a set of tax precedents distinct from Earl and its progeny, so the follow-up since 1930. In the true leased employee cases, an employee is under a legal duty to provide services to a corporation or trust, and the corporation or trust is taxed on the income of the employee's services produced. I wonder why they did that. I mean, it's one thing to say that you're working for a corporation, but they could have easily said provide services to a person, right? Use the word person and still be ambiguous on who the fuck they're talking about. But here they're at least saying corporation, and then in parentheses they're saying or trust. See, and they reference C. Rubin versus the commissioner, Laughlin versus the commissioner. So they're giving you what they're calling the true leased employee cases. So that's right here. If you want to continue your research on that, here are some cases that go back to 1938 and 1970, 1942. Here, what is conspicuously missing is a legal obligation between the employee and the entity that pays the taxes. The White Family Trust could not make Russell White work for Litho Productions, control his activities, or determine the amount of his compensation. You hear this, right? The White Family Trust could not make the rules, right, in your trust indenture of how much he's going to make, controlling his activities, his duties within the job, or determine his compensation. Why is that? Because the company don't belong to the trust. That's like a given. Like that's like all in your face right there. Like all the trust could do was receive whatever amounts Russell White was paid. See Vunick versus the commissioner. And number 5 down below. Rejecting leased employee argument in a similar family trust context. So that's another case rejecting that argument that this guy is throwing out. Assignment of professional basketball player's salary to Puerto Rican corporation ineffective for income tax purposes, where corporation had no ability to force a signer to play basketball. Because that's what it is. It's for you to be able to, for the trust to pay the taxes on that income, man, the income has to be generated from a source within the trust. Whether it's the trustees doing it on behalf of the trust, using the property, things of that nature, it has to come within it. And this, even though they're not directly saying it, but you could see it, they're saying it like, okay, well, The corporation doesn't have any power to make this guy go play basketball. Well, no, because basketball is it's an independent organization. They have no control or say so in that, or over the trustee himself or whatever it was. The person who was a basketball player, if he was a trustee. The taxpayers' consolidated brief seems to argue, at least for Russell White, that the conveyance of the lifetime services of the grantor to the trust creates the necessary legal obligation. I don't know what this abbreviation stands for. BR 19 through 25 and 31 through 34. They don't give a link. The short answer to that argument is that the obligation is entirely illusory. The grantor, in his capacities as employee and as trustee or trust manager, is on both sides of the transaction. There is no one to enforce the ostensible, this means I think showingly or obviously, right? Obligation. Concededly, more was conveyed into both the White and Schulz family trust than the grantor's earning abilities. A different set of rules applies to gifts to a trust or otherwise of income-producing property. Broadly speaking, these rules treat as gifts for income tax purposes gratuitous transfers of all the interest of the donor that the donor possesses, and deny that effect to attempted gifts of carved-out partial interest. To the extent, however, that the res of these trusts consisted of income-producing property, the trusts are invalid for tax purposes under the grantor trust provisions under the Internal Revenue Code, and that's 671 through 77. These provisions are exclusive means of answering the following questions. How far must the grantor go in the direction of a complete surrender of his personal authority over the trust property before trust income will be treated as belonging to the beneficiaries? So they're asking you got to remember, if a trust is meant for you to 100% give up legal ownership of the property completely, then the question is, what does it take for that to happen? That's what they're asking here. What does it take for someone, a third party observer could look in and say, okay, that property does not belong to him no more. He has no rights, control, or anything, and it belongs to that person over there. It says, put otherwise, what rights may the grantor retain without continuing to be regarded as the substantial owner of the property transferred? Now what rights may the grantor retain? What powers are you keeping? I don't know what this citation is here, though. It looks like a book, not a case. I don't know. It says supra, so it's above here. They already stated it. The application of these provisions to a family trust is painstakingly considered in Westenberg versus the Commissioner in 1978, and we joined the Eighth Circuit in Vanook, supra, in adopting its analysis for our purposes. So the controlling case is the 78 case. It has been affirmed right here by the Eighth Circuit Court, and now this court is saying, yeah, we're jumping into. The main thrust of the grantor trust provisions is that the trust will be ignored and the grantor treated as the appropriate taxpayer whenever the grantor has substantially unfeathered powers of disposition. What did they say? When they should have just said the grantor, but they said ignored and the grantor treated as the appropriate, right, taxpayer, but the grantor also. Whenever, oh shit, what did I just do? Sorry about that. I just clicked the button and now I just screwed it all the way up. Let me see if I get back. Okay, right here. The main thrust of the grantor trust provisions is that the trust will be ignored and the grantor treated as the appropriate taxpayer whenever the grantor has substantially unfeathered powers of disposition. The hallmark of such discretion is that the grantor can unilaterally or with the concurrence of someone who is not an adverse party. Yeah, so he'll have the hallmark of such discretion is that the grantor can act unilaterally or with someone who is not an adverse party. An adverse party is a term of art defined in the statute as any person having a substantial beneficial interest in the trust which would be adversely affected by the exercise or non-exercise of a power which he possesses respecting the trust. Right? And the reason why this is important is because it's like there's certain powers the grantor is not supposed to have no more by himself. So it's like he gotta be shown that everything that the grantor does is at arm's length, and he's not showing ownership in any way. He's not the owner no more. He's a new owner actually because he's an owner as in the capacity of a trustee, but nonetheless he is not the owner no more, and that's the whole purpose of this. So think about those trusts that people are teaching or people have already received or the templates they're looking at. Look at these powers. What did they just say right here? They haven't even said which powers yet. The first thing to note is that the beneficiaries, although their interest and the grantor trustees may diverge, are not adverse parties in the statutory sense because they have no powers respecting the trust. Thus, the statute does not regard the general law of fiduciary duty as an adequate guarantee that grantors will not deal with trust property as if they owned it outright. The taxpayer's contrary arguments must fail, and they citing these. It says, let me read this again. The first thing to note is that the beneficiaries, although their interest and the grantor trustees' interests may diverge, are not adverse parties. They're saying they're like one and the same in the statutory sense because they have no powers respecting the trust. I don't really know what he means by here. The second point is that despite efforts to skirt the grantor trust provisions by careful draftsmanship, these trusts in substance, if not in form, violate the statute. The drafters, or more accurately, the person who designed the kit these taxpayers bought and used, are labeled the husbands and sole grantors and given them little or no beneficial interest in the trust. Right? So this is the husband being the sole grantor of the trust, where they have little or no beneficial interest in the trust, right? Which is something similar that I talk about. But that's not the issue. It's all the powers that were not distributed properly or completely revoked, permanently. But nonetheless, it's that right there. Apparently, to avoid threshold problems of equivocal gifts. Let's see what this is. 16. They give you 14. They give you a court case. Gift of annual interest coupons to son while father retained underlying bond is ineffective to avoid father's income tax because he really never transferred the property. Assignment of 1 year's trust income to children ineffective to avoid income tax where a signer kept right to receive income in prior to subsequent years. So he kept the right to take back the income. It wasn't just for the year. That's the thing too. He just said just for the 1 year, but because there was a power for the income to be taken away in any other year, right? You got screwed. Gift or of part of trust income stream effective to shift incidence of taxes, though balance of income stream retained, where donees and donors' interest would both last as long as the income stream did. When they have given the wives duties as co-trustees and substantial beneficial interest to bring them within the definition of adverse parties. So they created a trust where the grantors had almost no benefit at all, right? And then they gave the wives duties that would make them adverse parties. The theory is that these maneuvers will prevent decisions made by husband and wife together from being constrained in violation of the statute. In this case, the Schulz family trust, these strategies do not work because most actions require only 2 of the 3 trustees to agree, and one of the trustees, the bookkeeper's wife, had no beneficial interest at all in the trust and was therefore not an adverse party. It was possible for any given decision to be made by one of the Schulz and the bookkeeper trustee. So through the door, he's right there. The White family trust also had a supernumerary trustee. This, I think, means more than needed, right? Or extra. Supernumeracy. Let's look. I think it does mean that, though. Is nerd stuff right here, nerd stuff. As a supremacy, he was given a variety of jobs. Supremacy, a person or thing present in excess of a normal or requisite number. So yeah, extra. Mrs. White's brother, but he resigned. So the White family also had, the extra trustee initially, Mrs. White's brother, but he resigned. For most of the period at issue, meaning the 3 years involved in these appeals, Mr. and Mrs. White functioned as sole trustees, and Mrs. White was within the definition of adverse party. Nonetheless, the grantor trust provisions were still violated, although in a different fashion. Despite the trust documents recitation that Mr. White was the sole grantor, Mrs. White was also a grantor. Immediately before Mr. White created the trust, and by documents simultaneously executed, Mrs. White conveyed all her interest in their jointly held property to him. That conveyance can be ignored either on the familiar tax principle that substance predominates over form, or because the parties themselves treated it as either a sale nor a gift. Mrs. White also conveyed some property directly to the trust. Thus, the statute can be applied with the focus that Mrs. White as a grantor. It then becomes clear that she could make unconstrained decisions about trust property and income because Mr. White, having no beneficial interest in the trust, was not an adverse party. So you can see how they screwed themselves. Up here, it took a little bit more, right? How they're saying that it doesn't work for the Schultz because of the bookkeeper had no interest in it during part of the time. And it was possible for any given decision made by one of the trustees and the bookkeeper trust, right? But here, it's her actions and how they stated where the property came from and all that, right? All the documents involved, right? It's not just the fact that he wrote down that on the trust instrument that the husband was the grantor, right? But it's all the other documents involved with the property that told a different story, that the wife transferred all the property to the husband. Now, what she should have done is she should have paid a tax on that. because now it could be considered as a gift and the tax is made, and now he's the complete owner of it, and she has no interest in it. And now he creates the trust with that property. He didn't do that here. Just transferred on over. You know, it's still a contract. Whatever that transfer was, where's the consideration? Where's the sale? Where's the exchange? What is it? What is this transaction? Because otherwise, it just looks like you gave it to him to put into trust for both of you, to create something with your interest in mind, right? If it's a gift, it's not your interest in mind. Where was this at? Or because the parties themselves treated it as neither a sale nor a gift. Mrs. White also conveyed some property to trust. Thus, the statute can be applied with focus on Mrs. White as the grantor. It then becomes clear that she could make unconstrained decisions about the trust property and income because Mr. White, having no beneficial interest in the trust, was not an adverse party. And this is something that I paid attention to in mine, even though, well, that's for another story, but that's something I paid attention in mine. Moreover, this same argument would invalidate for income tax purposes the Schulz family trust if it had operated without the bookkeeper's wife as spear carrier. Mr. and Mrs. Schulz, like the Whites, owned their property jointly, and Mrs. Schulz, like Mrs. White, conveys most of her holdings to her husband. She too conveyed some unspecified property directly to the trust, disregarding the indirection of the main conveyance. Mrs. Schulz also is a grantor with effective control over the trust. Her husband's 5% interest is insufficient to make him an adverse party. I don't know the number, right? But I do know that for you, if you are a grantor and you want to be a beneficiary, right? What is it? You cannot have more than 5% of the total value of the trust, right? As that you could benefit from. And I don't see another number above that 5% that would tell me what makes an adverse party. I can't tell you if it's 6%, 7%, or whatever, but I don't know. If you have to look at the words that they use for adverse party, and I think that means substantial control, or substantial interest, beneficial interest. So if just going off substantial, you would think it has to be 50%, or maybe the number 35% comes to mind for some reason, right? And that's from other stuff that I've read, right? But to be honest, I don't know. So but at least they're saying the husband's 5% is insufficient right here. So for those of you who want some income where you could get under 5% and not be considered an adverse party. The relationship among the parties in these trusts present exactly the sort of potential problems the grantor trust provisions were designed to meet. Furthermore, nothing in the remaining terms of the trust imposes any substantive limits whatever on the trustees may do. In both trusts, trustees' powers shall be construed as general powers of citizens of the United States of America. To do anything any citizen may do in any state or country, subject to the restrictions herein noted. They shall continue in business, conserve the property, commercialize the resources, extend any established line of business in industry or investment, as herein especially noted, at their discretion for the benefit of this trust, such as viz. Buy, sell, or lease land for the surface or mineral rights, buy or sell mortgages, securities, bonds, notes, leases of all kinds, contracts or credits of any form, patents, trademarks, copyrights, buy, sell, or conduct mail order business or branches thereof, operate stores, shops, all this stuff, right? Advertise different articles of business, borrow money, right? The trust property for the payment thereof, pledging the trust property for payment of, hypothecate assets, property or both of the trust in business projects, own stock in or entire charters of corporations or other such properties, companies, or associations as they may deem advantageous. So this is what the judge is saying, that they had almost unlimited power, right? Not only were they restricted within themselves, but the general powers was that in their individual trustee capacity, right? Like they were able to do what they needed to do. Like they had too much power, and these are grantors that you're talking about here. Grantors can't have that power. The whole purpose of this trust is what? Relinquish power. Then what they're supposed to do is make it 100% irrevocable. And the only thing to do that is if you could properly write the trust in such a way where you could pre-plan everything. You're writing in your trust, which could be 50 pages, 75 pages, or 100 pages, right? But nonetheless, its purpose is so you don't have to amend it in some future, for some future purposes. It takes a lot of insight for that. A minute of resolutions of the trustees authorizing what it is they determine to do or have done shall be evidence of such an act is within their power. So that's just their minutes. It is in the unlikely event that these terms are not broad enough, the trustees shall regard this instrument as their sufficient guide, supplemented by from time to time by their resolutions, which is bylaws. Said resolution to be ratified always by a majority of the trustees then in office and participating in the issuing meeting, covering contingencies as they arise and are recorded in the minutes of the meetings, which are the bylaws, rules, and regulations of this trust. I like how they added this though. So ratified by a majority of trustees then in office, so they are trustees, and they are actually participating in the meeting. I think that's actually important because then it could be like you could get a vote from a trustee, but the guy's not even going to be present. To me, you want everyone present and accounted for. So it's like if you ever need signatures, stamps, seals, whatever, witness, all that. Lacking both procedural and substantive limits, these trusts violate Section 674A because there is unconstrained power to dispose of the beneficial enjoyment of trust, income, or corpus. Violate Section 676A because there is unconstrained power to revest title to the trust property to the grantor. So they could give it back to themselves. And violate Section 677A because there is unconstrained power to distribute trust income or accumulate it for further distribution to the grantor or the grantor's spouse. But they are doing it to themselves. This is more, even though they're violating it, right? They're not stating that they're doing it to themselves, since they are the trustees. These are powers you can't have no more. The actual expenditures may document that all powers but the power to revest title to the trust were actually exercised. So everything, the actual expenditures may document that all powers but the power to revest title to the trust were actually exercised. Since the Schulz and Weiss retain all the indicia of ownership, I want to say like evidence or the intent of, or something like that. Indicia. Signs, indications, and distinguishing marks. Learn footnotes. Marking used to address labels. meaning to point out. Legal definition. Yeah, I'm only giving it to them. I looked it up in another book though. But it says signs, indications, or indistinguishing mark. Let me see. Legal. Really? It's the name of a company. It says the same thing, meaning signs or to point out. For example, certain evidence or documents may indicate that something is probable. Tend to show or indicate that something is probable. Like the things that you're doing is showing some form of an outcome. Well, in our case, what are they saying? That since the Schulz and Whites retained, right, they have all the showing of ownership in trust property, then that means they never bifurcated the trust, the titles. Their joint personal income tax returns for 72, 73, and 74 should have reflected that ownership. Given the deeply rooted instinct not to pay more taxes than the law requires, and the endless changes that can be wrung in trust draftsmanship, we do not suppose that any single opinion can put a definitive end to devices like Schulz and White's family trust. They're saying they're going to see more of them. Nor do we mean to intimidate taxpayers and their attorneys in their search for the equivalent of the better mousetrap. Nonetheless, it should be clear that certain avenues of tax avoidance are closed. Lucas versus Earl prevents attempts to assign income away from its earner, and the least employee theory is not an easy escape route from the Earl doctrine. And though the analysis may differ from one case to another, the grantor trust provisions will generally defeat attempts to create trust of family income producing property without surrendering any of the family's rights of ownership. If taxpayers persist in ignoring these truisms, right, we will in the future be sympathetic to the Internal Revenue Service's assessment under 26 U.S.C. 6635A of penalties for underpayment of tax due to negligence or intentional disregard of the rules and regulations of the Internal Revenue Code. And this looks like he quoted it for VNUC, so this has already been stated. Right? This part right here. And he's repeating it again to these guys. Like they in this opinion, he's stating that he don't see this stopping at any time. Right? And it's not gonna stop I guess for lack of a better word, either people that don't know what they're doing or scammers in general, right? It's not gonna stop them either, right? It's a mousetrap, he's calling it. But he's telling, in this case, he's at least stating that there are certain things that are facts that you need to pay attention to. If you willfully, in this case with this judge, if you willfully see that you're disregarding and not understanding the law at the very minimum, dude, he's telling you he's going to be sympathetic to the Internal Revenue and screw you over even more. The judgments of the tax court are affirmed with cost to respondent. Here the annotation. Let's see what they give. Yeah, see, I didn't read this part. I didn't see that Mrs. Schulz conveyed most of her interest in the jointly held property and her right to receive a salary to her husband, but in turn conveyed it to the trust. Mrs. White did substantially the same thing. Both women also conveyed some property directly to the trust. Information digested from cross-examination of Mr. Schulz before tax court. The testimony does not give exact figures of the various categories of expenditures where they can be identified. They are supplied from the trust return. There's another court case, man, that I wouldn't mind doing a follow-up for this one. And they put everything. The guy was some a journalist, and he put everything. I'm talking about his gas, his outfits, his makeup, his everything for whatever he needed for the broadcast that he had to do. Like Earl involved a lawyer who made a contract with his wife, right? That future income earned by them would belong equally to both. Similarly disregarded for tax purposes an insurance agent's assignment to a family trust of his right to receive renewal commissions on policies sold in earlier years. Together, the cases hold that the assignment of compensation due or compensation to be earned is taxable to the assigner. And this is right here. So aside from Earl, that's why I think Earl is so short. Because this is the case that I probably should have read. Elvering versus Eubank. Elvering is the commissioner. And that's this has to be a 1920s case. 1940. So yeah, so a better understanding would be probably this one. In terms of coming off of it from Lucas, from that point of view. From that context. I'm big about context, so let's see. Well, I think that's it for now. You guys could read these annotations yourselves. It just added bonus information. That's all it is. I don't see nothing. I highly recommend you guys go look up these sections. 26 USC 671 through 77. Let's go see specifically what they violated. Maybe you could catch now how not to violate those. Remember, the whole goal is not to create the things that they govern or they are objects within their rule. That's how you maintain privacy. But hopefully these guys enjoyed. Hopefully it wasn't too long and it was able to be followed through. But like and subscribe, of course. That always helps. And hopefully these guys have finally finished or caught up on the other videos. This is, I think, my 20th video for YouTube. I think 16 in total dealing with trust. This one was trust, but it was more along the lines of source of income. So it could come in two ways. Taxation, source of income rules, or trust. I chose the source of income rules. I think it's a little bit better. All right. Have a good one, guys. And until next time.